Good afternoon. My name is Jim Townsend, and I am the director of the Levin Center at Wayne State University Law School. It is my pleasure to welcome you to today's panel discussion entitled Opioids and Emerging Justice Reforms, which the Levin Center is hosting in partnership with the Journal of Law and Society. Thank you for joining us. Today's panel is the second of three panels we are hosting as part of the Journal of Law and Society's symposium entitled Opioid Paradigms: How Crisis Can Inform Change. In a moment, I'm going to turn things over to the moderator of today's panel, Professor William Ortman of Wayne State University Law School. But before I do, I'd like to say a few words about the Levin Center. Former Senator Carl Levin founded the Levin Center in 2015 upon his retirement from the United States Senate, where he served for 36 years. The Levin Center is headquartered at Wayne State University's Law School and also has an office in Washington, D.C. The mission of the Levin Center is to advance bipartisan, fact-based oversight and civil discourse as instruments of change. In the past few years, the Levin Center, with our partners at the Lugar Center and the Project on Government Oversight, have trained hundreds of congressional staff and state lawmakers and staff in the techniques of bipartisan, fact-based oversight. We also support the conduct of research on important oversight topics and maintain an oversight scholars listserv that a number of people who are with us today contribute to. And we advocate for the right of the legislative branch to conduct oversight and for the vigorous use of that power by Congress and state legislatures to ensure transparency and accountability in government. Before I turn things over, I want to congratulate the Journal's Symposium editor, Veronica Walrad, and the Journal's editor-in-chief, Ben Van Bar, for their excellent work on this symposium. And I also want to acknowledge Margot Lapere, Elise Bean, and Ben Ike of the Levin Center staff for their hard work in making this event possible. Now I have the pleasure of turning things over to Professor Will Ortman, who is Assistant Professor of Law and the Edward M. Wise Research Scholar at Wayne State University Law School. Will writes about legal and institutional design of criminal justice, and his current scholarship, which focuses on plea bargaining, which is a practice that accounts for the vast majority of criminal convictions in our American courts. He is an ideal person, I think, to moderate this panel on opioids and emerging justice reforms. And so with that, I will turn it over to Will. Thank you very much.
Well, thanks, Jim, and thanks to the Levin Center and the Journal of Law and Society for hosting us in this extraordinarily important and timely topic. It's a privilege to be joined by three exceptional panelists to have that discussion. I'm going to go ahead and introduce the panelists, and then we'll move right into the substance of this. So we're going to hear first from Professor Jelani Jefferson-Exum, who is the Philip J. McElroy Professor of Law at the University of Detroit Mercy School of Law. She is an extraordinarily prolific scholar who writes about criminal sentencing, comparative criminal policy, policing, and race in the criminal legal system. She's written recently about the shift in opioid sentencing away from heavily punitive policies of the war on drugs and towards a welfare-based approach for some addicts facing criminalization. We'll then hear from Professor Valena Beety of the Arizona State University Sandra Day O'Connor College of Law, also the Deputy Director of the Academy for Justice. And that's a criminal justice center that connects research with policy reform. Also, exceptionally prolific scholar. Her 2018 book, The Wrongful Convictions Reader, was described by Barry Scheck himself as the best introduction yet to the impact of the innocence movement and the systemic study of wrongful convictions. Before entering academia, Professor Beety was a federal prosecutor and an innocence litigator. And before that, she was my law school classmate. And then we'll hear from Brittany Kelly, who's the Associate Director of the Hall Center for Law and Health at the Indiana University. She holds both a JD and a master's in social work from IU. And before joining the Hall Center, she worked as a public defender at the Marion County Public Defender Agency, primarily working with that county's problem-solving courts. So I hope that everyone is as excited for this panel as I am, and I will turn things over to Professor Jefferson-Exum.
Great, thank you so much. Well, I also want to thank the Levin Center and the Journal on Law and Society for putting this panel together and for inviting me to join in this conversation. I am really just excited to be a part of this very important discussion, and honored to just get to add my perspective to this. And so I do have a PowerPoint that I will start to share with you all so that you can just follow through with some of the images as I talk. So I have the sort of task today to set the stage by giving my perspective on the war on drugs and what would actually need to change in our collective perspectives on drug sentencing in order to move from what I see as a warfare approach to sentencing to more of a welfare or wellness mentality. And I'll share how I think the opioid crisis may or may not be a vehicle for getting us there. So if we just sort of start in the beginning, the war on drugs officially began in 1971 when President Nixon decried drug abuse as public enemy number one. So I know many people have heard about this, but I want to just direct you to thinking about the rhetoric here. So the goal of War Rhetoric was really clear. It was to cast the drug abuse and the drug offender as dangerous adversaries of the law-abiding public. And so that would require military-like tactics and warlike weapons to actually defeat. And so criminal sentencing would end up becoming one of the main weapons that was used in this pressing combat. In continuation of the war efforts, we get the Anti-Drug Abuse Act of 1986 that was passed under President Ronald Reagan. It was a bipartisan effort that was widely approved and supported, and of course came to sort of some of those folks who supported it came to regret that decision much later. But it instituted weight-based, highly punitive mandatory minimum sentencing laws to deal with drug offenses, and that has persisted for upwards of 35 years to this point. So when the act was passed, crack cocaine was touted as the greatest drug threat. So crack cocaine really pushed the narrative of drug sentencing here. And the crack offender, the vast majority of whom were Black as far as law enforcement went, they were subject to the harshest mandatory minimum penalties. And so if we think about this war rhetoric, like any war, the consequences of the war on drugs have been widespread casualties, including the devastation of many communities, families, and of course, individuals. And the increase in racial disparities in punishment is a consequence of the war on drugs. Fiscal catastrophe in penal systems across the country is a consequence of the war on drugs. And so I'll take you just through a few statistics to show you. Okay, so this may be a graph that many people have seen, but it tracks the incarceration rate in the United States from 1910 up through 2000, and you see that there's that huge spike in the 1980s. And so the story there is this is when we get that punitive, highly punitive, weight-based mandatory minimum drug sentencing scheme, thanks to the war on drugs. But if we break that down a bit more and think about the war, the enemy, and how the weapon of mandatory minimums was actually deployed and who it was deployed against, then we see a racialized story there. So in the same time period, if you take a look at the orange line, that gives you the rate of white incarceration during this time. And it's the rate of Black incarceration of Black people that really mirrors what you see on the left. And so it really shows that story of the targeted enemy that the war on drugs was focused on. I'll show you a bit more. So if we think specifically about crack cocaine, because that ends up having really one of the more interesting stories, but also one of the starkest stories of these types of disparity. And I'm calling it a weapons accuracy report because you're just thinking about how that weapon of mandatory minimum sentencing, of treating crack offenses more harshly than powder cocaine offenses, how that actually played out. And so we had the Bureau of Justice Statistics in 1993 giving us information on how this weapon of sentencing, of harsh drug sentencing was actually working out. Again, we get more statistics about this in 1995. This is from a United States Sentencing Commission report saying that 88.3% of crack cocaine offenders were Black. Talking about this 100-to-1 crack cocaine to powder cocaine quantity ratio as the primary cause of this disparity. This was set up again in that mandatory minimum drug sentencing scheme where you had to have 100 times more powder cocaine to trigger the same mandatory minimums that you would get for crack cocaine, though they are made from their base is the same. But crack cocaine, the enforcement of crack cocaine offenses was focused on Black communities. Continuing on, now we're in 2002, and the Sentencing Commission is reporting to Congress saying, hey, everyone, an overwhelming majority of crack offenders were Black, 91.4%. These are the folks getting these longer sentences, 84.7% in 2000, and then explaining that the average sentence for crack cocaine offenses is 44 months, almost 60% longer than the average sentence for powder cocaine offenses. And so it's already, the story here is, of course, one of racial disparities that we see a lot. But I want you to think of it about the way that I'd like you to think about it is as a war tactic, that there was a war on drugs, defined enemy, and the weapons were operating as intended. And so then I'll just show one more that here we're in 2004, and the Sentencing Commission is explaining that revisiting the crack cocaine thresholds would better reduce the gap than any other single policy change, saying if you just do this, you would see great improvements in racial disparities in drug sentencing. And so you would think that, all of this would be perhaps okay, or at least explainable if there were actual purposes of punishment that were being fulfilled. But when you look more at sort of thinking about who's buying and selling drugs, who's possessing drugs, who's using drugs, we do not have this stark racial disparity. So there on the left, you see that rates of drug use and sales by race, with it being pretty comparable across for Blacks and whites, with whites outpacing Blacks in the use of drugs. But then when you go to the right and you look at what's happening with law enforcement, with punishment, with sentencing, drug-related arrests are overwhelmingly Black, drug-related incarceration overwhelmingly Black, drug-related incarceration on the federal level as well. So the same thing that was happening on the federal level was being mirrored in the states. Now, what the war on drugs has not done at all, of course, is eradicate drug abuse in the United States. And so now, nearly 50 years after the drugs became our national enemy, we have a new face of drug abuse, and that's the opioid addict. And so in October 2017, the opioid crisis officially became a public health emergency under federal law. And while it's largely understood that this was mostly a symbolic statement, little practical effect, the rhetoric is markedly different than what it was during that purported crack epidemic of the 1980s that I just talked through. So rather than the drug offender being the enemy, the opioid addict has been cast as the American everyman, right? The opioid addiction problem has been known as the crisis next door. That's what it's been called on online spaces. It's been said that it can affect any American, from the all-state football captains to the stay-at-home mothers. And so polls show that when it comes to opioids, Americans favor treatment over punishment. But even though this is the case, there hasn't been any responsive sweeping drug sentencing reform, no huge shifts from warfare to wellness. And I don't believe that there will be any real shift until we reckon with actual roots and systemically racist roots of the war on drugs, drug sentencing being used as a weapon. It's the system that we still have today. It's used disproportionately against Black people, and that won't change until that particular community is no longer seen as an enemy, and until there are efforts at actually repairing the damage caused by the war on drugs. We can have a more sympathetic view toward the opioid defendants, but wholesale drug sentencing changes for their benefit would mean making broader changes to that would disproportionately, or that would, I guess, benefit the disproportionately Black and brown drug offenders. And to get us there, that sort of wellness and repair approach, we actually have to reconstruct our whole approach to sentencing. And so I'll just end by kind of setting giving you one other framework to think about. I've talked about war, and I now want to talk about Reconstruction. And so I advocate for what I've called Reconstruction Sentencing, and it's a revamping of punishment that focuses both on uprooting oppressive systems and also restoring rights and communities. So this goes beyond just setting up drug courts or diversion programs for one group of offenders when the damage has been so widespread. And I'm using the framework of Reconstruction, as I'm sure many of you know. The Civil War ended, but it ended in 1865. There were efforts to integrate the Southern states from the Confederacy and the 4 million formerly enslaved people into the United States. And the Reconstruction era was hailed as being anti-slavery, a big anti-slavery moment, which has been said to have inspired a collective sense of optimism, a new dawn among the formerly enslaved Americans, or a new era was sort of the idea. But of course, at the same time that freedom was being hailed, the so-called New South was actually repackaging white supremacy into the Black codes as a system of neo-enslavement on recently freed Blacks. And similar to that post-war excitement, we have this current day thinking about the opioid crisis, an opportunity for, for sentencing reform, for focusing on wellness. However, the reality of what's happening today is really reminiscent of this era of Reconstruction, where there's a tendency to celebrate, but without actual systemic change. We're just repackaging oppressive punishment. And so we're already seeing that, where drug courts, diversions will benefit certain communities, but not others. And I'm happy to talk more about that later, because I don't want to take up too much of my time. So I'll just end by saying that the fact that Reconstruction itself lasted only 10 to 12 years and was followed by 100 years of Jim Crow is because there was never a true reconciliation and repudiation of the racist basis and damage of slavery. So slavery just became repackaged. And that we have the danger of that happening when we think about using a crisis for change. If we don't completely rethink our sentencing approach, our purposes, our point of sentencing, reconstructing sentencing so that it actually, or punishment thought so that it actually is responsive to community needs, then we just end up doing the same thing over and over again. And so I'll just leave you with this quote from a Vera report on Reimagining Prison. It's a Reimagining Prison web report, which says that inequitable treatment has its roots in the correctional eras that came before it, each one building on the last and leading to the prison landscape we face today. So far, we've just built on the oppression that our country started with, without actually dismantling it, acknowledging it, and reconstructing. I'll stop there. Thank you very much.
Thank you, Professor Jefferson-Exum. I'm going to toss it to Professor Beety in a minute, but first let me invite our audience to use the Q&A function to pose questions to our panelists. After the three panelists speak, we're going to have a good amount of time for a discussion, and we'd love to have your questions as part of that. So with that, let me turn it over to Professor Beety. You are muted.
Thank you. Let me also start my little alarm for how much time I have, because I know I'll talk over. Thank you so much for having me today and to be able to present with such amazing colleagues and with Professor Ortman and his pivotal work on plea bargaining and rethinking about whether we should have, just like a national attorney general, whether we should have a national public defender. I love that. And also, to be with my colleague, Professor Jefferson-Exum. I always learn from her when she presents, so thank you very much, Professor Jefferson-Exum. I'm going to share my own PowerPoint as well. And I am focusing on rurality and the opioid crisis and prosecutions. So I am the Deputy Director of the Academy for Justice at Arizona State University, and I'm also a Professor of Law at Arizona State University, Sandra Day O'Connor College of Law. The Sandra Day O'Connor College of Law does acknowledge that the law school is located on the ancestral lands of the Akimel Udum, and the school also acknowledges that Arizona is home to 22 sovereign tribal nations. We are a mix of a rural and an urban state. with intensely rural areas, and those rural areas have been dramatically impacted by the opioid crisis, just as my former home, West Virginia, has been. So what is rural? When we think of rural, we generally think of white rurality, just as we think of a white opioid crisis, which again, we've learned more about that from Professor Jefferson-Exum's presentation. But just because rural areas may be ethnically monolithic does not mean that they are necessarily white. In fact, visions of white rurality exclude African Americans in the Black Belt across the Deep South, Latinx communities in the Rio Grande Valley on the border of Texas and Mexico, and then American Indian tribal communities in rural areas across the Southwest and the West. So rurality does include people of color. It is not monolithically white. What is often similar about rural areas is the frequent commonality of poverty. So notably, we see here areas of persistent poverty. These are also generally areas of food scarcity, of unemployment, and a lack of adequate health care. So these rural areas suffer disproportionately because of the impact of poverty. And you see on this map, you can see demonstrated the Black Belt across Mississippi and Alabama, where over 92% of Black Americans who are living in that rural area are living in that extreme poverty. And then you can see the Rio Grande Valley along the border of Texas there as well. And finally, according to a national census, Native Americans are more likely to reside in rural or non-metropolitan areas than metropolitan. And here we see that poverty rates for people of color in rural areas are higher than if they are in urban areas. For most, this is a quote, for most minority groups, minority status and non-metropolitan residents represents a quote unquote double jeopardy that dramatically increases the risk of experiencing poverty. So I focus all this time on poverty because poverty impacts the people in rural communities, but it also impacts the systems. And the system I'm focusing on today is the criminal justice system. So if we're looking specifically at people of color in rural criminal court, we're going to see the impact of the opioid crisis hand in hand with enhanced charges and enhanced sentencing that Professor Jefferson-Exum pointed out. In these rural communities, we often see a lack of funding for courtroom players, so prosecutors or defense attorneys, which leads to a captured system. And then we see, again, that rural communities of color are impacted by the opioid crisis and also punished. So what do I mean by a captured system? So criminal courts in rural communities are more likely to be composed of a few repeat players. There's not a lot of people, there's even fewer lawyers, it's a few repeat players. It's the same prosecutor who runs for re-election again and again, and then that prosecutor becomes a judge after a period of time. So these small locked communities have patterns of behavior and often are captured by those patterns of behavior, but also by dependence on the court itself. So interestingly, in a lot of rural communities, we only have part-time prosecutors. We don't have full-time prosecutors. We have part-time prosecutors who are dependent on maintaining their contracts with the town and being in good favor with the town and with the judges. On the other side, we often don't have public defender offices. That means that the attorneys for a defendant are going to be appointed, court appointed, which again captures the public defenders with an obligation to, obligation isn't the right word, but with a prioritizing of staying in good favor with the court. So as much as public defenders or, court-appointed attorneys are supposed to have an allegiance to their defendant and their individual defendant, a court-appointed attorney is thinking about all of the cases that they have and continuing to, again, maintain the good grace of the court so that the court will still appoint them cases and they can maintain their livelihood. So again, we see how the prosecutors and the defense attorneys in rural communities can be frankly beholden to a court and also to the town in terms of their contracts. And finally, I think I mentioned this, but prosecutorial power is consolidated with only a few prosecutors, and many of them run unopposed in local elections. I highly recommend Carissa Hesseck's work on this, and I encourage people to think about running for, I mean, obviously I know that in Detroit you have a phenomenal attorney there for the county, for Wayne County, but in many rural areas, there really is a need for more people to be pursuing these offices. I'll just give one example. So I lived in West Virginia for 7 years. Over that period of time, there was this county, Putnam County. I knew the prosecutor, the one county prosecutor, right? And over 5 years, they did not have one case go to trial. Not a single case over 5 years. That means every single defendant pled guilty. That doesn't mean the prosecutor wasn't charging people. He was. Just every single defendant was pleading guilty. And again, I think you see that in a captured system. So takeaway, a small group of poorly funded repeat players can corrupt criminal legal systems in rural areas. And we've seen this intersection against people of color in rural communities. So overdoses are the #1 cause of accidental death nationally. And although the opioid crisis has been a white rural narrative, again, this narrative ignores communities of color. It's a narrative that ignores Native American communities in the Southwest that are seeing high rates of overdoses and ignores the high percentage of people of color who are dying in urban cities. This is just an example of the Native American overdose deaths that we see in the opioid crisis. This is from 2018. This continues to be an ongoing issue. And the response has been, as Professor Jefferson-Exum pointed out, oh goodness, that means I have 1 minute left, has been harsh charges, including charges of drug-induced homicide. So bringing charges of homicide against an individual when that person shares a drug with someone who then overdoses. So charging the person who shared with homicide. These have been a increasingly common response in the opioid crisis. And frankly, were created during the crack cocaine epidemic. People of color are disparately charged with drug-induced homicide, where an overdose is characterized as a homicide. This is just one example of a county coroner who, in his death certificates, he says that the person has died from homicide if they have overdosed. So if you choose to sell heroin, you're killing people, you're murdering people. So you have a death certificate that says homicide when there's been an overdose. So again, that supports charging the person who shared the drug with homicide. So this is kind of a cycle of, we see rural people of color who face part-time prosecutors, quote-unquote defense attorneys, and they're captured by the rural court. They're also suffering from the opioid crisis, and they're more likely to be charged with heightened crimes like drug-induced homicide. All of this, the more harsh charges, reinforces an already established system of pleas, like you see in my example of Putnam County, West Virginia. So briefly, some prosecutor initiatives that are currently being examined right now are, one, partnering with pre-arrest and prevention programs. So before arrest, trying to partner when there are people who look like they may be entering the criminal legal system because of drug use. Two, focusing on the decision about whether to prosecute. So we have here Baltimore City State Attorney Marilyn Mosby, who dismissed over 1,000 cases during the pandemic. The vast majority of these were possession of drugs and possession of drug paraphernalia, low-level offenses that could have a dramatic impact on people's lives. She has dismissed many of these. A third is sentencing review. So after someone is convicted, examining whether their sentence is disproportionate. And there are prosecutors' offices who do this. So Valerie Newman, who is here in this photo, who is alumna of Wayne State, or Wayne Law School, she directs the Conviction Integrity Unit for the prosecutor's office in Detroit. And she has been one of the people who has been considering looking at sentences and whether sentences are disproportionate and unjust. Finally, what about the possibility of post-conviction drug courts as reentry? Prosecutor Mosby in Baltimore has been moving in this direction about whether instead of drug courts, which have largely been seen as very problematic and not necessarily helpful to the current population of people who are charged with an offense. What about instead offering it as a re-entry tool for people who have already served their time in prison and for them to re-enter into society through a drug court model? And I would just recommend this issue piece that just came out recently by Fair and Just Prosecution on drug courts, decarceration, and harm reduction. This is an important conversation right now because the Biden administration is supportive of drug courts, and it's a prime opportunity to really look at the drawbacks of drug courts and what alternatives there may be. Thank you very much, and I look forward to your questions.
Terrific. Thank you very much. We will hear next from Brittany Kelly.
Hi, everyone. Thank you so much for having me. I've learned so much from my fellow panelists already, so hopefully I can add something of value for us to discuss further in the Q&A. So let me share my screen. And start my timer as well. Okay, so I will be discussing community level intervention strategies to confront the criminalization of substance use disorder. Specifically, I'll be going into cross-sector collaboration along the Sequential Intercept model while applying a critical race theory lens. So we'll unpack all that together. But first of all, I do have to say that although I am a lawyer, I am not your lawyer, so please do not construe this presentation to be legal advice. So with that, we know that substance use disorder is a medical diagnosis. It's classified as such in the DSM-5. It's understood by the medical community to be a medical condition. However, an estimated 1/2 of all people in prison meet the criteria for substance use disorder. And alarmingly, someone enters the criminal justice system based on an allegation of drug possession for personal use every 25 seconds in the United States. So next, I want to talk about how this criminalization of substance use disorder has disproportionately affected the Black community, just like my fellow panelists have. But to do that, I'd ask that we apply a critical race theory lens to this conversation. So if you're not familiar with critical race theory, it is a theory that acknowledges that the legal profession has upheld racism in the past and even currently in the present, and is working to dismantle that. So there are 4 critical questions when using critical race theory lens. I'll let you read them for yourself here, but the last one is probably the most important, and it asks, how can the law be used to dismantle race, racism, and racial inequality? So with that lens in mind, like some of my fellow panelists have said, we know that over their lifetime, white people are more likely than Black people to use illegal drugs. However, Black adults are more than 2.5 times as likely as white adults to be arrested on charges of drug possession, and 4 times as likely to be arrested on charges of marijuana possession. In terms of incarceration, this disparity continues. Black people are more than 10 times as likely to be in jail and 6 times as likely to be in prison than their white counterparts. And Professor Jefferson-Exum did such a great job talking about this. I won't go into much detail here, but it's worth noting the stark differences in the response to the opioid use disorder epidemic when it was largely associated with the white population, as opposed to the war on drugs and the harsh sentencing penalties there when drug use was largely associated with the Black community. So many advocates across multiple disciplines would agree that legalization and decriminalization of substances should be our goal. However, that can be a slow-moving target. Currently, no drugs are decriminalized at the federal level, and the only federal attempts to decriminalize anything has been marijuana. Although a lot of states have now legalized marijuana, and some are even decriminalizing other substances, depending on where you live, this can be a really slow-moving goal. So what can we do in the meantime? So this is where I want to spend most of my time with you today, which is laying out tools for community-level intervention, specifically the sequential intercept model and cross-sector collaboration. So if you have never seen it, here is the sequential intercept model. And what it does is it details how a person with either a substance use disorder or a mental illness comes into contact with the criminal justice system and then transitions within it. Specifically, I want to focus on Intercept 0, 1, and 2. So before I move on, let's look at this picture together at Intercept 0, 1, and 2. Intercept 0 is about the community. The person has not come into contact with the criminal justice system at all. It's just asking, what is the community providing them? Intercept 1 is when law enforcement may get involved, but notice that it is before an arrest is made, and it really talks a lot about law enforcement's ability to divert an arrest. And then Intercept 2 is after an arrest has been made and the person is at their initial hearing or their initial detention stage. So why do I want us to focus on Intercept 0, 1, and 2? Well, it really cannot be overstated, in my opinion, how important it is to keep people experiencing substance use disorder out of the criminal justice system. Like I said, we know that substance use disorder is a medical diagnosis. And so people don't belong in the criminal justice system based on their substance use disorder. But here are some arguments as to why we should do this. So first of all, when we address why a person is coming into contact with the criminal justice system in the first place, we can achieve community safety and overall reduction in recidivism. There's also a financial piece here. Research shows that when we invest only 10% into treatment rather than incarceration, we save $4.8 billion. And the cost savings translates to every dollar invested in treatment saves $12. The collateral consequences that follow a person with a substance use disorder related conviction are numerous, and they often last long past the person serving their sentence. So it should come as no surprise that this group is incredibly likely to be rearrested. So again, it's so important to focus on why a person comes into contact with the criminal justice system and keep them from doing so, so that they don't end up entrenched in the system and continue to be rearrested. So how do we do that? So in addition to using the sequential intercept model as kind of our map, we should also use cross-sector collaboration. And cross-sector collaboration acknowledges that these are really complex problems, and our clients don't experience substance use disorder in a silo, so our solutions should not be crafted in a silo. It's important to bring together various stakeholders, and collaboration obviously is key to this model. And also important is to involve the community that we're advocating for in the solution in order to tackle power dynamics at play. When we talk about cross-sector collaboration specifically for people experiencing substance use disorder, we we build recovery capital. So if you're not familiar, recovery capital is the assets that a person in recovery has available to them to help them either achieve or maintain their sobriety. But we know that a lot of people experiencing substance use disorder have maybe lost touch with family and friends, or are living in poverty. So they might not have as much recovery capital. So the community is uniquely situated to build this recovery capital, and cross-sector collaboration is the way to do that. So with my last few minutes, I'd like to give some examples of cross-sector collaboration along the sequential intercept model. So first is an Intercept 0 example, and hopefully I think a lot of this audience is probably familiar with the medical legal partnership model. I know that there are 11 MLPs in Michigan. So in Indiana, they've recently launched a project called Project CLEAR, which stands for Civil Legal Aid and Recovery, and it uses the medical legal partnership model to specifically target people experiencing substance use disorder. The referrals for Project CLEAR come from recovery programs or recovery houses, and the eligibility criteria states that the person must acknowledge that their recovery, their ability to maintain or achieve sobriety, is directly being impacted by a civil legal barrier they are facing. So the benefits of doing this are many. I'll let you read some of them on the slide, but I think the most important one to point out is that we can prevent relapse. One of the barriers that a Project CLEAR might help with is, for example, a person is facing potential loss of custody of their child due to their use of medicated assisted treatment. That's obviously a stressful life event, facing potential loss of custody of your child. So if Project CLEAR can step in and address that for them, we can reduce that stress and hopefully prevent relapse, and then in the same way, prevent that person from coming into contact with the criminal justice system. The next example I'll just discuss quickly because I know that there is a bail project chapter in Detroit, so hopefully everyone is familiar with it. But the bail project acknowledges that detaining people pre-trial before they're accused of any crime is simply just reinforcing poverty. The consequences of doing this are that people are more likely to plead guilty, they're more likely to be convicted, sentenced to prison more often. So the bail project works on getting people out of custody so that they can fight their case from a position of freedom. And they do so using this community release with support model. So this is a direct example of cross-sector collaboration because it relies on community partnerships to build up that person's recovery capital and support them in coming back to court. And then lastly, if I were giving this presentation to an Indiana audience or a state with a driver's license debt-based suspension system, I would talk with you about how important it is for a person experiencing substance use disorder to have access to a driver's license. However, I learned in preparing for this presentation today that Michigan recently passed House Bill 5846, which no longer suspends driver's licenses based on reasons that are not related to dangerous driving. So I left this example in here to show you that community level work and programs and interventions, they can drive larger legislative change, just like this example. So real quick, I'll leave you with a couple of takeaways. No matter what background you bring with you, whether you're an attorney, an aspiring attorney, a philanthropic leader, a government employee, there's something really for everyone to take away, hopefully today. First, I'd ask that you know the resources in your community. So know about the medical legal partnerships, know about the bail project, and then broker those resources. Whether you're a prosecutor or defense attorney or not, the chances that you will encounter someone experiencing substance use disorder are great. So broker those resources. And then work to break down silos in your community rather than construct them. And then I ask that you collect data while you're working on these programmatic and community level changes. Collect data that can then be used to drive larger legislative change. And then lastly, always use a critical race theory lens and ask yourself those 4 critical questions. So if you have any questions, I look forward to chatting in the Q&A portion, or you can contact me via email. Thank you very much.
Wonderful. Thank you so much. So we've got a number of great questions that have come into the Q&A. Please keep those coming. Professor Beety is going to have to leave at about 1 o'clock. So I want to start with a question directed to her. So Professor Beety, early on in your talk, you were countering the narrative that rural equals white. But how much does that vary by region, right? So the question asker's assumption is that the homogeneous, that's a tough word to say, of rural areas is different in the North and in the South. Thinking about migration patterns from the work of other sons. And then the question asker closes by posing this: what value, if any, is there in paying attention to how that perception may track reality differently in different areas?
So I apologize that I missed that question in the chat, because it's an excellent, oh, maybe it was in the Q&A. It's an excellent question, excellent point. Yes, so absolutely, many rural areas are ethnically monolithic. That does not mean that they are white. So again, the Black Belt is largely Black Americans, African Americans in a region spanning Mississippi to Alabama. And as mentioned, that was a community that was part of the Great Migration up to Indianapolis, Detroit, Chicago. And then obviously in my part of the world in Arizona, Native American communities on tribal lands. So those are frequently ethnically monolithic, but they are not white. So I think it's very important to be able to recognize that rural communities are not just white. And frankly, even in West Virginia, where I lived for 7 years, there's a small but strong community of what people identify themselves as Appalachians. So people who are African American but Appalachian. And Appalachian is probably the whitest region that we have across the United States, including Alaska. And yet there are still communities of color within those areas. Anyways, yes, I think it's very important. And I think it's particularly important in the context that I was sharing today, where we continue to see harsh, I would say overcharging, and then harsh sentencing of people of color in rural communities. So we may think that that's a problem for urban communities, but it's also a problem for rural communities, that racism spans urban-rural borders. And I'll just also add that many of the communities that continue to incarcerate people to long sentences and to prison are rural communities. So as we've seen a trend towards decarceration across the United States, rural communities and rural courts are more likely to continue to harshly sentence.
Thanks. Do either of the other panelists want to weigh in on that one? Okay, let me go to a question that was initially posed to Professor Jefferson-Exum, but that I think all of our panelists may want to speak to. And that question is this. So Professor Jefferson-Exum, when you were talking about Reconstruction sentencing, you mentioned it going beyond drug courts. Do you think that there's no role for drug courts? Do you think that there's a specific role that should be defined differently than it is? And Professor Beety talked about reentry, so maybe that's one avenue, but maybe there's others as well. Or what role do you think drug courts and maybe other specialized courts should play in Reconstruction sentencing?
Thank you. Great question. And definitely, I know other panelists can weigh in to this one as well. I'll just start by saying I think that drug courts, they have done positive things. There are really great success stories out of drug courts and all of that. But even in posing the question, you said specialty courts. And to me, that's where the issue lies. When it comes to drug courts being sort of an alternative to our usual way of sentencing. So they're the special thing, right? What that tells me is that they're just sort of picking at the fringes of an issue and saying, for a select number of people who we think may do well in this sort of environment, we'll kind of pull them out of what we usually do. And so there's the huge machine of what we usually do, the usual sentencing, the mandatory minimum sentencing that is happening in the background. And these are just special courts. So I see that as problematic, that it's not shifting, it's not reconstructing the way that we sentence, it's not shifting our attitudes and outcomes. And then when it comes to drug courts, the way that they're implemented, and so I like the idea of using them differently. So like as reentry courts, that makes sense to me. If we are keeping a sentencing model that's like the one we have. But a problem with drug courts also is because they're specialty, because they're seen as not our main way of handling these issues, the funding only goes so far, right? Which means that there are only a certain number of people who are going to be able to come through those courts. And when you look at the criteria, oftentimes they're very much tied to the types of factors that are going to disproportionately, again, exclude the communities that have been hit the hardest, like African-American communities. So if you have to have indicators of success, because a lot of drug courts get their funding continued through having enough success in their program, meaning low recidivism rates, it means you have to have, certain types of support. There's some indications about your kind of family structure, who's there to sort of stand by you through the program, all of these things. But my problem is that they don't really look to the damage that's been done in communities, really thinking about reconstructing, changing our entire approach, and they're just sort of the specialty on the fringes. But I know others have things to say about that as well, I'm sure.
So I'll just second everything that Professor Jefferson-Exum said, and how problematic it is that it is a special solution only for a narrow group of people, often for first-time offenders, but really for only a fraction of people who have substance use disorder and issues. And I'll just also point out that when people fail, then they end up spending that time in prison regardless. So people who are in drug court and fail often spend double the amount of time because they've been in this system, this surveillance system to keep up with the court. And then when they fail, they're then sentenced to prison time regardless.
I agree wholeheartedly with what both of you have said so far. I was a defense attorney in problem-solving courts, which is what we in Marion County refer to as drug treatment court, but it also includes mental health courts and veterans courts. So I saw the success stories and they were great, but the challenges that you've both mentioned are incredibly real. Along with some things you've mentioned, there it also allows for a lot of prosecutorial discretion when choosing what types of charges and crimes are eligible. And research shows that a lot of times people end up doing quite a bit of jail time through the system of sanctions that are set up, and maybe even potentially more jail time than they would have done had they resolved their case in the adversarial system. And then additionally, even if a problem-solving court or drug court is running perfectly, people ideally get offered a lot of resources to ultimately achieve and maintain sobriety. But my argument is that we should be offering that to everyone, and that all defense attorneys and prosecutors and people involved in the criminal justice system should know how to broker those resources and know how to think therapeutically rather than punitively. And like both of you have already said, if we leave that only to problem-solving courts, we're missing a lot of people there. So I agree with everything that's been said so far.
I'll just jump in because I see someone, Patrick, saying that problem is that there's still often a criminal conviction, right? Even if, so there can be two different ways. You could have where you don't get the conviction if you complete the drug court, or it can be you do still get the conviction. And there's a case that's getting a fair bit of attention in New Jersey where this woman 18 years ago had this conviction. She had substance use disorder. She, subsequent to this, she went through the drug court. She was successful. She became a social worker, so she could specifically serve people who suffered from substance use disorder. And yet she can't be licensed because she has that conviction. So her only hope right now is for clemency from the governor, just so she can be in a field to serve people with substance use disorder. So the conviction can be very harmful.
An important point. The next question is, it's addressed to Brittany Kelly, but I think that, again, it's one that all of our panelists may want to speak to. So the question asker writes, obviously the responses to the opioid crisis must be multifaceted. That said, I feel like opioid addiction is often framed as a criminal issue rather than a medical issue. I know that there are legal prescription opiates that often can serve as the catalyst toward forming a substance abuse disorder. What measures, if any, do you think should be taken to increase monitoring and distribution of legal opiates? Whoever wants to start can, yeah.
Go ahead.
Ms. Kelly, do you want to go first?
Go ahead. Take it away.
I will just briefly say that my spouse, Professor Jennifer Oliva, she writes extensively on prescription drug prescription drug monitoring programs, PDMPs, which document all of our prescriptions from birth control to hormonal, like if you're going through a gender identity change, I mean, all of our prescriptions, and those are very easily accessed by law enforcement and have been a law enforcement tool to punish people. So I think there's while there's a recognition that there can be concerns about prescription opioids, that there's a pushback on how that surveillance of prescriptions is really another police tool to prosecute people and arrest people, and not the doctors, but the individuals who are getting the prescriptions.
Thanks for getting that started. I would just add that, that's why in my presentation, and I think I noticed in my fellow panelists' presentations, I was careful to use the language of opioid use disorder epidemic as opposed to opioid epidemic, because some opioids, if obtained by a valid prescription, are not illegal. And it's important to differentiate that. There are incredibly valid reasons for opioid prescriptions, including chronic pain management. There's actually some really good articles available about this on the website Changing the Narrative. If you haven't heard of it, I invite you to check it out. There's a lot of really great, not just on this issue, but others as well, really great articles about how to change the narrative around the opioid use disorder epidemic. And that's one of them, that, legal prescriptions of opioids have a place in our world, and they have a value. So I would just add that.
No, just add one other perspective here, because I agree with everything that was said. And of course, there are, opioids with sort of medical uses, valid medical uses. But I think our entire conversation around drugs ends up being about what has valid medical uses versus what doesn't. And to me, what we really should be focusing on is why people are using whatever drugs they're using in the first place, because that's when we start to really think about community needs and community and places where services and responses can be appropriately used. All of those are something other than the criminal justice system. Right. But we've just used the criminal justice system as a blunt instrument. And I'll go back, to my presentation, which is that that there was a reason for doing that, because it was not about being responsive to people's actual, social, emotional, mental needs, health needs. It was about control. And that's what our criminal justice system has done. And it's done it to the detriment of Black and Brown communities.
Right, exactly. Which I guess I'll add to my original comments that decriminalization and legalization is ultimately the goal here. That's, at least for, in light of my presentation, that was the goal that I was getting at. So I think, like Professor Jefferson-Exum was saying, taking substances out of the criminal justice system and treating them like the medical condition that they can be, really addresses the problem more appropriately, just the way like we address diabetes as a medical condition rather than a criminal issue.
Well, and oh, go ahead, sorry.
No, please.
Well, I was going to move to the next question. So
I'll add one more facet of this, which is, again, looking at how people are differently treated based on, in our criminal legal system, based on class and race. So if we look at pregnant women who can be, you know, they give birth, there's a blood draw on them, even if they don't give consent, there's frequently a blood draw. And then if there are drugs in their system, that mother can be arrested, she can be separated from her child. This disproportionately impacts poor women of color, but also even if you test positive for methadone, like you're actually taking a treatment for your substance use disorder, and that's the healthy thing to do when you're pregnant. So if you test positive and it's methadone, you can still be charged. So there's a whole spiral of how this can expand out when it's addressed criminally.
And this has been a perfect segue to the next question that I wanted to get to, which points to decriminalization, recent decriminalization in Oregon, and the adoption of rehabilitation approaches there. And again, this one's addressed to Associate Director Kelly. What would that look like on a national scale? Would it be difficult to implement? Is it implementable? What would the challenges be?
So yeah, I'm glad someone brought up Oregon, because that's exactly what I was referencing when I said that some states have started decriminalizing other substances along with marijuana. I just didn't have time to go into full detail about that. But yeah, it's exciting for Oregon. And I think other states and the federal government can hopefully learn from it. As far as the likelihood of seeing this on a federal level, you know, only time will tell. I think our current administration, there's definitely a possibility with our current administration, but it was also mentioned already that our current administration has a preference for drug treatment courts. So that does not lend me to think that large-scale decriminalization is as close as we might want it to be. Like I mentioned, on the federal level, we've only seen attempts so far to decriminalize marijuana. So I hope that we can get there. As far as the likelihood of it, I think only time will tell, but I think that's why these community level interventions are important while we're also pushing for that larger legislative change.
Can I jump in here too with a bit of a cautionary tale? I hate to not, you know, be championing these advances, because I do think that they're important, and I am happy to see it. But I think we can take the marijuana story as a cautionary tale. So it's already happening in places where we have marijuana decriminalization, legalization, regulation. Is that if we're still not looking at it, I like that Director Kelly talked about this critical race theory lens. Similar, not exactly the same, but very similar to thinking about and looking at things through an anti-racism lens. What I'm promoting as Reconstruction Sentencing, but basically saying if you make changes without looking to how those changes are affecting sort of racially marginalized communities, or communities that are marginalized because of their race, you just perpetuate the same systems. So in these areas where, in these states where we're having these marijuana changes, what ends up happening is that there's a harsher crackdown on the, you know, illegal marijuana markets. And so there's actually been an uptick in arrests and incarceration for marijuana when it's seen as, you know, you're working outside of the regulatory scheme. But the reason why groups are working outside of the regulatory scheme is because they have not had access to getting licenses to sell, to grow, to distribute, and that is happening on in racialized ways, right? That it's communities of color who are not getting access to the legal market, and I'm purposefully calling it an illegal versus a legal market rather than a black market, which we could imagine happening with other drugs as well, because I was on a program when I heard someone refer to the legal market as the white market. And I thought, well, okay, that really says something, with, you know, but that is actually what's happening. And so, so that's the cautionary tale. And to me, it still rings of lessons learned from Reconstruction, which is if you don't actually focus on the real systemic problems and you just change systems, you just make some sort of, you know, these reforms without an anti-racism, critical race theory, Reconstruction type of lens, then you're going to perpetuate the same types of problems, and the same people, Black and brown communities, will continue to suffer.
Thank you for those answers. Next question is about treatment for people who are incarcerated. And the question asker poses this question: given the large number of jails that do not allow for medical medication for opioid use disorder treatment for people who use drugs while they are incarcerated, have there been lawsuits for challenging the denial of life-saving medication treatment for incarcerated people? And I don't know who might want to answer that, but open question.
I don't know. I don't have a good answer to that one. It's not something that I'm familiar with. Interesting question, but I don't have a good answer.
Same here, and it looks like Professor Beety might have just had to leave us. So I don't know of any lawsuits, but the question asker is right to acknowledge that it's incredibly difficult to obtain medicated assisted treatment in jail. Even if the jail has all the resources to provide it, it doesn't mean that the person gets it in time or gets it quickly or gets exactly what they were taking when they were out of custody. And the risk of overdose and death upon being released from jail, even a short stay, especially if the person did not receive medicated assisted treatment during that time, the risk of overdose and death are extreme. So it's one more reason why people experiencing substance use disorder just do not belong in the criminal justice system.
Yeah, and thank you for that answer, because it gives me something. It sort of made me think of something else that I could say here. Again, I don't know about lawsuits, but just thinking about anecdotal stories from incarcerated individuals that it goes beyond those who have substance misuse disorders to anybody who's trying to get any sort of medical attention and treatment in prisons, that the hoops you go through to get that is very difficult. And I think at the heart of everything that we've talked about, even thinking about the opioid crisis and using it as a catalyst for change, at the heart of all of this is really about thinking about human dignity, right? And how people deserve to be treated, how their situations deserve to be addressed. And so I think that we just have in our criminal justice system, and really in many of our systems, we've developed institutions and systems that do not act with human dignity at the forefront. And so that's just also what plays out in prisons, which is why it's difficult for people to get medical attention. I've heard many stories and know this from incarcerated friends and family members who have had trouble being even believed about their medical situations, whether it has to do with drug misuse disorders or with any other medical issues. And it all comes down to human dignity.
Thank you. So the next question, it's a little bit longer, but it's a really nuanced question. I don't want to miss any of the nuance. So I'm just going to go ahead and read the admittedly lengthier question. So I'm curious, the question writer asks, about the possibility of reconciling two somewhat disparate narratives I've often heard about the opioid crisis and our responses to it. One narrative, which I heard echoed in Professor Jefferson-Exum's presentation, is that past iterations of the drug war, example, versus crack cocaine, favored harsh punitive responses in part because law violators were constructed to be Black, whereas responses to the opioid crisis leaned toward treatment and leniency because of the white, quote, everyman construction of the opioid addict. But at times, responses to the opioid crisis have been quite harsh. See, for instance, the rise in drug-induced homicide prosecutions. And one narrative I've seen to account for that is that the lives of predominantly white victims of the crisis are valued, and that aggressive enforcement is a way of expressing that social valuation of their lives. Are these stories?
I think we lost you. We lost you at
You
the
lost
end.
your mic at the very end.
Okay.
You said, are these stories? And then we...
compatible? And if so, how?
Okay, I think that's a really good question. And I think that those two narratives, those two paradigms, whatever you want to call them, they are both happening and they are compatible. Because you have to, again, think about systems and institutions, right? And so we have a system sentencing, of drug sentencing, of dealing with drug issues in the criminal justice system. And we've built an entire system around it with a specific way of doing things that very much was built on seeing certain communities of color as enemy communities. That was the narrative that was set up, and the law sort of fell in line with that narrative. And there's a lot of, this is not just sort of people talking about this. It's not just how it feels. We have transcripts, we have data, we have people's own words about this, the war on drugs. And so that's there. And so now we're in a situation where we've lived that for, war on drugs for 35 years, but the foundation, so the racist foundations for the war on drugs for the entirety of American history, right? And so we've lived that already. So we're now in and part and parcel with that institution. So as new, in that institution and system, as new, crises develop with a different face, so like the opioid crisis, where you have the white community that has been afflicted, this tremendous loss of life, but it affecting the white community, then we do see this changed narrative, right? But what the question is pointing out, that the response, even though the narrative has changed, which is very important, the response has still been very harsh in many instances. And it's because we're we've come up in a system where our response to drugs, because it's just, it's been ingrained for all these years, our response to drugs is harsh punishment. And so that is the system that we're operating in. It just so happens that we're talking about it a little bit differently, even having these types of conversations, because the face of the crisis has changed, but they're both happening together. I do think that there's a big aspect of this that is about the valuing white lives over other lives, which gives us both sides of that coin as well, where we're going to talk about things with sort of this wellness health aspect, but the tools that we use, we're still stuck in our system. We haven't changed it. The tools that we use still end up being harsh punishment, because we're responding to the fact that, these white lives have been lost, and we're afraid of that. We're going to keep punishing harshly rather than rethinking. Now, just my last point here is that what Director Kelly said about, I like how she said they're called problem-solving courts, which is nice, but it's sort of like, why isn't this whole affair problem-solving from the beginning, right? And that's really, the point of all this, which is that we should be, starting from square one. What are the actual problems here, but being honest about them, and race and racial outcomes has to be a part of that discussion, and being just real with the fact that that we do have this different valuation going on, and that we have to confront that and then deal with it. So I think they're both happening. It's a long answer, but it's a nuanced question, so I figured it warranted a long answer. So thank you.
Absolutely.
I agree with you completely, Professor Jefferson-Exum. I will just add, again, that Changing the Narrative website is really a good place to start if this is one of the first times you're starting to think about all of this. There's some really good articles there around this. And then also, I would invite everyone, just as you're watching the news tonight or in the next couple of weeks, and you see stories about drug use, think critically about those. Are we talking about a person who is white experiencing substance use disorder? And if so, is that narrative about, a loss of potential or a loss to a community? Versus when we're talking about drug use by a Black person, all too often the narrative is about violence. So I think a lot can be learned just by critically thinking when we're absorbing our media.
Great, thank you. So our next question comes from a clinical pharmacist specialist and researcher who's interested to know what your opinion is on drug courts mandating MOUD, which I think is medication for opioid use disorder, with intramuscular naltrexone, which I may be mispronouncing, without providing other treatment options for the individual. So any views on that practice?
I can start by saying one of the core values of the social work profession is self-determination. So I think that's incredibly important here. One of the word that triggered me to answer this way was the use of the word mandate. And I think it's so important to acknowledge people's self-determination in how they want to address their addiction. That's when you really see change, is when a person has control over that. So is there a place for medicated assisted treatment for a person experiencing addiction? Absolutely. But it's that word mandate that I wanted to draw your attention to.
And I would have the same response, only connecting it to a point made earlier about, human dignity. If we're starting from a standpoint of thinking about human dignity, human autonomy, then that should really be our guiding value. And so we can all just think about, what sort of decision-making every just individual human deserves to have they deserve to have a say in how they're treated by the government. And so if we're starting there, then I agree that there are places, of course, for medicated treatment, but the mandated part of it is concerning to me as well.
Great. Okay, so next question. One way that you can tell that an intellectual idea is catching on is when it's generative of other ideas, when it causes people to have their own thoughts on stuff. And we have a great example of that here, Professor Jefferson-Exum, with your discussion of Reconstruction approaches to sentencing. So the question asker writes, one thing that came to my mind with Reconstruction approach is Truth and Reconciliation Commissions. Might that approach involve Truth and Reconciliation Commission style proceedings? If so, what do you think that would or should look like?
A great answer. So I teach in addition to con law, crim pro, criminal sentencing, those sorts of classes, I also teach a course on race and American law, which allows me to think about sort of the impact that American law has had on race and race relations in this country, and then vice versa, the way we think about race and race relations, how that has helped to shape the law. And it allows me to sort of look at it with a broader lens, not just the criminal justice system, and to have really fascinating discussions with awesome students about these issues as well. And so this idea of after we've gone through looking at all the problems in US history and how really oppressive the law has been, we get to the point of thinking about now what, right? What do we do? And so Truth and Reconciliation comes up. And it is, it's a framework that has a lot of promise, but does also have some limitations. The first one I'll say is that with Truth and Reconciliation, that first step of truth. So having Truth and Reconciliation Commissions, hearings, things like that don't work unless there is unless there's an admission of wrongdoing. And in this situation where we have systems and institutions that have been the wrongdoers, it requires, the government actually say, okay, this is the way that we've wronged groups and communities, and thinking about how to reconcile, but first starting with that truth. So that's sort of a first issue. The second is that for Truth and Reconciliation hearings and commissions to be sort of restorative to a community, I guess is the best way to say it, is that there has to also be community trust, that their best interests are in mind, that they're really going into hearings that are where they can speak without punishment, where they can express what's going on without condemnation. And I wonder if we're at a point, I don't think that we are, but I think it's a place we could work toward, where there's been enough repair with communities that have been really affected by our harsh punishment, war on drugs, criminal justice system, to where people will feel as though they are trusting enough to come into a space to say, here's what's happening with me and my family, and trusting that they're not going to be then criminalized for that. That's the piece that has to have some repair there. And Truth and Reconciliation Commissions in South Africa, post-apartheid, that was actually a limit there as well, that there were groups who said, we don't really trust that this is real and that anybody really has our best interests at heart. So it's been criticized in that way, and I think the same would be when criticism if we tried it in the US. Not to say that we shouldn't. I think we should be going down all sorts of roads that can lead us to a better day. And we just have to go into it with eyes open about what's actually needed. And here, I think community trust building would be the first step.
Great, Director Kelly, do you want to add anything?
No, not on that point. That is best left to Professor Jefferson-Exum. That's her area of expertise.
Terrific. So thank you. Let's see, where do I want to go to next? Another question for Professor Jefferson-Exum. How do you think the prison industrial complex has played into the lack of comprehensive sentencing reform in this country?
Yeah, good question, because it's recognizing that we do have a prison industrial complex, that the prison industry is a large industry where there are a lot of groups that make money, and that it sustains communities, right? Where you have a prison, communities actually lobby to have prisons built in their area so that they can have employment, so the corrections officers will come from that community. You have all sorts of other companies that stand to make money from prisons, from telephone services, commissary, on and on and on, right? And so it means that if there are going to be any changes to criminal justice reform, punishment reform, that will significantly decrease the prison population, you can bet that there are going to be folks who have, stand to lose monetarily, who sort of come to lobby for against those changes. So that is, that's real. And also, if we think about any sort of sentencing reform, it obviously requires legislative changes. And these would be the same folks, our legislators, congressmen, congresswomen, who are lobbied by these various interest groups. So it's very difficult. I always say, because it all seems like such huge problems to tackle, where do you start? And it really has to start with us, that to the extent that this is political, that, the more that there are community voices demanding changes, the more we'll see political movement. But you do just have to realize that we're also up against big money. And so that has to be a piece of it as well. The more that there are groups with money that are willing to step up and support criminal justice reform, the easier the path to get things done.
Great. Okay. So next question, I'll direct this to Director Kelly. You talked before about concerns about mandating any sort of medical treatment, but then the flip side of that is the availability of treatment for those who do want it. And so a question invites you to comment on the lack of medically assisted treatment options in jails. Is there a justification? Is there an explanation for why MAT is hard to receive in jail?
Yeah, so my understanding is sometimes it's just a matter of supply. A lot of times, I'll give a different example, a person with a mental illness who takes a certain medication out of custody, and even if the jail has available maybe a generic brand of their mental health medication, it might not be the exact medication they were taking before they came into custody, and that can be, really have a lot of consequences. So medicated assisted treatment is kind of the same way. It's just a matter of supply and access that these jails may or may not have. And then also the decision whether or not to administer it also plays into that as well. How quickly can the jails administer this? How willing are they to administer it? So those are some of the barriers to medicated assisted treatment in jail.
Great. Okay, so we've been talking mostly at the level of courts and the incarceration system, and to some extent the substantive law. But let's focus on policing as well. So question asks, right, how would the kinds of changes we're talking about to prosecution and courts and law change policing? Is there a connection between the kinds of reforms that are emerging around opioids and the newly prominent energy in the United States, thinking back to the protests in the summer and just mass awareness of the idea of prison and police abolition, to reform or to abolish the criminal legal system as it stands today?
Yep, there's definitely a connection there. And even in my thinking about Reconstruction sentencing, so I'm working on a paper on this now. I say, even though I'm calling it Reconstruction sentencing, it goes beyond just sentencing, because it's about all the things that lead up to that punishment point. And so policing is certainly a piece of that. And it's the story that that I started with. So if you think about war on drugs, police were a big tool in sort of, targeting that enemy and getting them into the system. And this is a big reason why, you have the charts that show that drug use is consistent across races, drug sales consistent across races. With drug use, I should say, actually, with whites using drugs a little bit more. But still, when it comes to arrests and then ultimate incarceration, you have such a higher rate of this falling on Black communities. That's policing, right? That's starting with policing. And it was about police priorities, where police would be placed, what their directives would be, what communities to go into, how they had to police those communities. So it all part and parcel with everything that we've been talking about is about changing law enforcement, both priorities and practices. Right. And so when you think about the defunding the police movement, and what it's really about is saying, think about what communities actually need and want. And then, using policing either not at all in many situations or in a more appropriate way. Another thing that I can throw out, we hear about defunding. Another term is called unbundling the police. So it's thinking about the fact that not every situation warrants police presence. If we're thinking about, say, substance misuse, mental health issues as well, right? That the police are often not the proper parties to call to deal with whatever sort of, psychotic break someone's having, whatever sort of reaction to substance misuse they're having, and that there are other groups, other professionals that would be better to assist. It's just that we have to have our system set up so that that's available. People call the police because they don't know who else to call. But if our systems are reset so that those sorts of resources are available, police do not have to respond there, which also means that we're not going to have the same types of arrests and entrance into the criminal justice system in those instances. But truthfully, it should go beyond just instances of mental health crises or drug misuse episodes, things like that. It really should go into everyday policing, that the presence of police in many communities is overbearing, and there's no need for it. And it would cut down on what we see quite often.
Thank you. That was great, and I agree with you completely. I'll just bring us back to the sequential intercept model to frame this discussion too. A lot of those resources that Professor Jefferson-Exum is talking about could fit in that intercept to zero, which, as a reminder, is before someone even encounters the criminal justice system at all. So building up those community resources, again, can achieve this goal of diverting people from the system at all. And then intercept 1 is when law enforcement is called. But intercept 1, if you look back at that graph, actually there's a large portion of that intercept that happens before an arrest is made. So that's pointing out that law enforcement, when they are called to a problem or to an incident, they have the discretion to make an arrest or to not make an arrest. So I think that's the big takeaway from intercept 1, is how do we encourage law enforcement officers to not make an arrest, especially when it's related to a substance use disorder or mental health crisis.
Great. And so I think we have time maybe for one last question. It segues nicely from your reference to community resources. But the question asker asks, at what age do you think we should start focusing on offering preventative community resources and interventions? Is this, yeah, go ahead, sorry.
I was going to say, interesting question, because when I think about community interventions, resources, I don't think about age, right? I think about communities as sort of existing with a variety of people at different points and stages in their lives, right? But that the focus would more be on needs rather than specific ages. And so, so I guess the best answer that I can give is we should start today with whomever is in a community that has specific needs that can be addressed, right? And that we should be thinking that those needs should be addressed outside of the criminal justice system. Even if we traditionally think about them as criminal justice problems, we need to, throw that away. So we're thinking about, crime. We don't have to think about what all these things that we consider crime as really being criminal justice problems, but instead they are community need. They highlight community needs and places for community investment and attention. And that happens despite the age of folks in that community, which will, I'm sure, have people of all ages who will have different sorts of needs at different times in their lives.
Yeah, I agree. I think start where you feel most equipped to come up with a solution, and the age is not necessarily something to sway you one way or the other. But then as your community starts building these resources, then it would be great if your community had something for someone at every age to address a lot of these issues. So I know that doesn't happen overnight. So I would say if you are, if this is sparking ideas for you as to where you can invest in your community, then any age is a great place to start.
Terrific. Well, I think that's a really nice note to end on. So will everyone please join me in thanking our panelists. This has been a very productive and very informative discussion, which I really appreciate. So thank you very much to our panelists, and thanks to everyone who attended. There's another panel tomorrow, and I don't have the topic of that in front of me, but Veronica could put it in the chat. Everyone will be able to see that. So thanks very much, and hope to see many of you again tomorrow.
Thank you.
Thank you.